All right, welcome back to the Safety Pro podcast. Before we get started, big shout out to our partners in safety, Mighty Line Floor Tape. Go to mightylinetape.com/podcast. Get a free sample of their floor tape if you need to mark out your facilities to keep your workers safe. That's where you want to go, the official floor marking tape of the podcast, mightylinetape.com/podcast. And of course, our official safety services provider, Aero Safety. Go to aerosafetyus.com and get a quote from Drew and his team. I mentioned that we sent you. You get 10% off. They got you covered. Everything from inspections, training, custom written programs for your company. aerosafetyus.com. Thanks you all for your support. And we are joined once again by Phillip Russell. Phillip, how you doing?
Blaine, good to be back again. Thanks for having me on.
Oh, it's always great to talk to you. And man, there's a lot to talk about nowadays. So we're going to keep it focused on just one specific area. But for those who may be just hearing your name for the first time on our podcast, go ahead and give us a quick introduction about you and what you're all about.
Sure. Thanks, Blaine. So, again, thanks for having me back on the podcast. Always happy to come out here and talk about workplace safety and health legal issues. So I'm Phillip Russell. I'm with a law firm of Ogletree Deakins. We're an international law firm, got about 1,100 lawyers, but we are a boutique in that all we do is focus on employment law, labor law issues for employers, for the business side. My specialty is OSHA. So I am an OSHA lawyer. And I've handled over 225 fatality cases, hundreds of other kinds of cases all around the country, and really keep an eye on OSHA about what they're doing, what they're not doing. And certainly when we have a change in administration, what changes employers might expect. But my job really, I used to say that I fight OSHA for a living, and really that's not true. My job is to hold the agency accountable to the law. And as long as we do that and working with our clients, then we can get results. And the results that we seek in every case is how do we help clients avoid or minimize OSHA citations while helping improve safety? That's what we do. And so happy to be here and talk about it today because, as you said, lots to talk about.
Yeah, Phillip, I love your approach too. And you're always very open and honest about, saying that you want to make sure that employer rights are protected when it comes to interacting with the government is not the same as subverting safety. Yeah, I love how you are laser focused on improving safety. You can do both of those. That the two things can be true, right? We do want to protect businesses from government overreach or unlawful overreach, and help our employers keep their workers safe to the highest possible standard. So I love that. Yeah, man, a lot to talk about. I thought for this episode, we would focus on, it's a general topic, but there's two parts in my mind, and I'll let you kind of clarify them. One is, oh my gosh, they're going to toss out the OSHA Act of 1970. It's going to get tossed out. Who's proposing that? What support does it have or not have? And what are your thoughts on that piece before we move to the bigger chunk?
Yeah, it's the No OSHA Act, or the NOSHA Act. Is Andy Biggs in Arizona. This is his third time introducing the bill.
Yeah.
And the bottom line is it's got zero chance of passing. So let's start right there. Zero, none, will not happen. Now, that's not to say it's not a good idea. We could talk about that in a different context. But what is this bill going to pass? The answer is a very hard no. And why is it a hard no? Well, look to the Senate. Even if Andy Biggs were to rally enough Republicans to support this cause, which I'm not sure he could, but even if he could, let's say you pass a bill in the House, you go over to the Senate, you do not have 60 votes in the Senate to eliminate the federal safety agency. It's not going to happen. And you need 60 to overcome the legislative filibuster, or you get rid of the legislative filibuster. That won't happen, not for this issue. So that's why I give the chances of Andy's third time around, or Congressman Biggs' third time around, a big fat zero. Hard no, not going to happen.
And I think the first two times, I know the first time, like zero cosign, like nobody on any party signed on to. It was just one dude. He didn't have any counter proposal Like usually when you say we need to abolish this because we have this to take its place, or this already achieves that, there's nothing. And it's a congressional act, the OSH Act. Like, how hard is it to just toss out an entire congressional act that actually went through the legislative process?
Well, the process of getting rid of a law is the same as the process of passing a law. You have to pass a law to get rid of a law. So that's why you have to have a law. So that's why it's just not going to happen. And I know there's been a lot of folks in the safety world that you and I live in that have, kind of, I don't know, Chicken Little this whole issue, the sky is falling. It's not. It's not going to happen. The alternative, when you listen to what Congressman Biggs wants to do on this, is to send it down to the states and let the states handle it. I guess that's similar to what's going on with the Department of Education, except that it's not the same. Maybe similar, but it's not the same. Because if you do that, I'm frequently, trying to put out these thoughts on LinkedIn all the time and talk about it. Be careful what you ask for, because in your particular state, I'm in Florida. We don't have a state plan right here. And our Fed OSHA folks, I've worked with for a long time. What might you get in Florida? Are we going to get something more akin to South Carolina and their state plan? Or are we going to get something more akin to California? They're not the same. There you go. And and even if you answer the question one way now, all right, well, advance the calendar 10 years, 15 years, 20 years down the road, and you now have a state plan in your state where you formerly had Fed OSHA, but that state plan in your state has now flipped political influences, and now the other party's in charge. You might get California. So I think there's some concern there. The other issue I've got is, and I've got a lot of, my clients run the range, Blaine, from mom and pop shops, small, construction companies, small manufacturers, all the way up to the big mega construction companies. And the feedback, certainly from the mega construction companies and the bigger companies, those with multi-state operations, is that now you're going to have a different fall protection standard or trenching standard state to state to state. You're going to have to hire more safety pros, which might be good news for your audience. You're going to have to beef up your safety function. And so I think that, and I'm not saying it's a good or a bad idea. I will say this, Blaine, I am somewhat open to the argument that maybe we should be doing safety more primarily at the state level, because Fed OSHA is a $600 million agency, which frankly isn't that big. They only have, I think, 1,700 Fed OSHA compliance officers right now when there are millions of workplaces. So,
and here's something we forget. I saw a post. I'm not even kidding. And of course, it was somebody who couldn't spell OSHA last week. And now all of a sudden they've got the Google PhD. And they posted, hey, they're thinking of getting rid of OSHA, the administration, not the OSHA Act, and making states, take care of safety. And then the follow-up to that post was, why don't we just erase all the lines on the roads while we're at it? And I thought, hey, genius, half the country already has state-run plans.
Mm-hmm.
They have lines in their streets. Last time I drove through many of them. So half the country, it's actually more than half if you count the ones that they have state plans for public employees, but federal OSHA covers private employers. But half the states already have their own state-run plan with their own state inspectors approved by federal OSHA. Maybe that's a more realistic scenario where it's just the federal offices and compliance officers. It's more of a light footprint, a smaller footprint for federal OSHA, but they help states comply with the OSHA Act, the minimum requirements, review the programs, look at the data, audit, not inspect employers, but audit the state's management. They have to have a minimum of state inspectors, things like that. I mean, I could see that being a realistic scenario. Is it a bad thing that the rest of the states join the other half and run their own state plan?
Well, the reaction you've summarized, in terms of the safety lines or the lane markers on the road. I mean, that's just political rhetoric and probably not likely from someone who knows, the world as well as you and I do. So I think it's kind of, you got to be able to filter out that sort of nonsense. But, and I think you did, and with your comment, it's a great question to ponder, because think about it this way. What's most effective for safety? What's the most effective thing we can do through our government, state or federal, to help protect workers? Now, let me just remind everybody, I'm a management side lawyer, but like you pointed out earlier, safety matters to me. And that's the kind of question that sometimes people that are on the other political, side of things think that management lawyers, employment lawyers, safety people that work for companies, we don't care about safety. I think we care more about safety because we're in it every day and we can help make a difference. One of the ways I could see safety improving dramatically is getting rid of the political influence on safety. And that's where I think Andy Biggs, Congressman Biggs, and others are frustrated with Fed OSHA, because all too often over the last, it's been around 50 years since 54 years now since 1970, but certainly in the last several decades, it's become very political. The last 4 years in particular, we had an inordinate amount of focus of OSHA's resources on the warehousing industry, the distribution industry. That industry, statistics did not show that industry was getting workers killed or exposed to hazards at any rates higher than anyone else. Yet we had a national emphasis program on warehousing, targeting really and the reality is targeting specific employers that I'm not going to name or discuss in particular for my own reasons.
Likewise.
I can't.
Yeah.
Right. So, but that industry, I think, was unfairly targeted, politically targeted, because big labor wanted to have more organizing done in that industry. So it was a purely political decision. And now
union organized labor aside, this isn't a union bashing episode or statement, but you cannot deny that when the National Labor Relations Board, like some things changed there and kind of tied to OSHA, and they kind of started to collaborate on efforts that. Yeah, you got something that even if they say it isn't, it walks like a duck and talks like a duck. It smacks of political influence.
Correct. And look, and to be fair, I can point to Republican administrations where the agency also did political things, not so much with who they targeted, but who they just didn't target.
Who they didn't. Yes.
So, correct.
Yeah.
So, in the circumstance we're talking about now, what I'm concerned about, with innovation and change at the agency, if we get it, is that the nominees are actually now the confirmed Secretary of Labor, Lori Chavez-Durenner. No secret that the Teamsters, this isn't a political statement or union bashing. They openly supported her. They said, we want her to be the Secretary of Labor. President Trump appointed her, and the Senate approved. The man that's going to head OSHA, David Keeling, and to be fair, I don't know him at all. I've got friends and colleagues that know him. Seems like a great guy. He's also very close with the Teamsters. They wanted him to have that job. That concern from an employer's perspective and trying to hold OSHA accountable and get them out of politics, I'm concerned about that. It may not go the way I'm worried about, but we'll see.
Yeah, I think it's interesting. I never understood but are you pro-union or are you anti-union? It's like, how should that even play into the equation? Well, the answer is because it is a political appointee. And okay, anytime the executive branch appoints somebody, it is going to be by definition a political appointee, because in the sense that I need somebody that is going to be aligned with our administration's platform, our agenda that we were voted on. And that's why votes matter. Like, go vote, people, So what do you see being a balance of, okay, well, every executive gets to appoint their cabinet and appoint these positions upon confirmation, advise and consent of the Senate. What would make sense then to kind of not play both sides, but persuade both sides or assure both sides that this isn't a political job. I'm appointed by a politician, yes, but we have a duty, we have a charge, this agency does, and we are going to fulfill that mission.
Well, I'm sure you're familiar with the term key performance indicators, right?
Yeah,
KPIs.
yeah.
Ever in the corporate world, you know your KPI. What's the KPI for OSHA? My answer to that question is fatalities. I would open up the data and I would look and see, let's see, where are workers getting killed and what industries and what employers? Start there. There's nothing political about starting with the data. And, if I were the head of OSHA, which I'm not, but if I were, I would start with that question. Where are workers getting killed? In what industries and what jobs are they doing and what specific employers? And I would take 100 of my top compliance officers. I don't care where they live. I don't care what the geography is. I don't care where the employers are. I would take 100 of my top compliance officers, and that's all they're focusing on for 2 years. You would move that needle overnight, Blaine. And I don't care about who's red, who's blue, what the politics are, Republican or Democrat. You would move the fatality needle overnight because you would find you're focusing on certain industries. And it's no secret, fall protection is the number one killer. The roofing industry is having problems.
Yeah. Construction,
and construction, but subset of construction is roofing. And there's a lot of good employers in that industry, but it also, when you look at the data, again, I'm not trying to say are you a good employer or bad employer. What industry, what employers have the data? Let's focus our resources there. Instead, what the agency's done, and that's why I think you invite things like Andy Biggs' initiatives on trying to get rid of OSHA, is because It's become so political that you spend all your time and resources going after warehousing industry employers who aren't getting people killed the way that folks are in fall exposures in construction and roofing. That's the biggest frustration. That's the criticism, that it's become political. Let's make it less political by getting it back to the states. But again, to your point, it's only about half. You're not talking about the whole country. Half the states. And the most innovation we have when it comes to protecting workers with new regulations is coming from the states. It's not coming from Fed OSHA. It's coming from state plans.
Yeah. States are able to do a couple of things better, and I'm not saying I'm advocating for 100% state coverage, but I do recognize states are able to make changes quicker when they see a need for them in the regulations, in their state regulations. They're able to adapt quicker. They're able to specialize. Some states are heavily ag. Some are heavily petrochemical, oil and gas. Some are heavy fintech, finance, medical insurance, white collar, company states. They're better able to adapt and cater to those types of employers. On the flip side, I can also see it, being politicized or used. Let's say we want to attract more manufacturing. Well, our state safety laws aren't like the ones over in, Mississippi or Alabama or the inverse of that. I could see that happening too. So I guess there would have to be, that's why you have to have this federal minimum, right? Where federal OSHA just becomes this approving authority and oversight of the state plans and how they manage it. There's got to be some standards the states have to meet minimum. You go above that, that's fine. But if you're not employing inspectors, you're not targeting industries with certain rates, and you're not tracking those rates, then you're not doing your job. You're not meeting the federal standard. I could see a blend of the two and to be able to compensate for those pros and cons. I wouldn't have a problem with it. Like you said, half the states we deal with already have their own state plan.
Well, Blaine, I mean, I love this discussion, by the way. I think it's something that's important, but I think it all should be driven by what's the most effective means by which we can address worker safety. And maybe a federal agency, the way that we've done it, since 1970, is not the way to go. Maybe there's a hybrid approach where there is a Fed OSHA, but all it does is, operates in a similar role to how it audits state plans now. I don't know. It's a good discussion. But here's the thing: we won't get there through the legislative process. Going back to my initial comment that you're not going to get there, but I do see a pathway that that might be something that folks aren't paying that much attention to. And this is the approach that this is the approach that might come to the courts. So, and I'm going to begin this with just a quote from a Supreme Court case from last year. This is Justice Clarence Thomas, and this was in a challenge to OSHA in an OSHA case. And this was denying certiorari, which means the court said, 5 of the justices said, we don't want to take up this case. It was the all states refractory versus sue case. And here's what Justice Thomas, remember that? So here's what Justice Thomas said. He said, quote, "The Occupational Safety and Health Act may be the broadest delegation of power to an administrative agency found in the United States Code." He continued, "If this far-reaching grant of authority does not impermissibly confer legislative power on an agency, it is hard to imagine what would." And he went on to say that at least 5 justices have already expressed an interest in reconsidering the court's approach to Congress's delegations of legislative power, specifically regarding OSHA. So with the Loper-Bright decision last year, and everybody knows that court name, that was the case in which the Supreme Court got rid of the Chevron deference rule. And what that was where courts had for decades under the Supreme Court's decision in Chevron versus EPA, had said that, well, if an agency has a reasonable interpretation of the statute that created the agency and gave it its power, then that's fine with us. Well, last year, Loper-Bright, the court said, no, that's not how it works. That's not the way the Constitution was structured, and you need to not, courts, be deferring to agencies on what they can and can't do. You need to read the statute for yourself, judge, and determine whether or not this conduct that they've engaged in is within or not within or outside the authority in the statute. But what this all states refractories case does is one up that from Loper-Bright. And the one up is maybe the statute itself is unconstitutional because it gave too much power to an executive agency in the language of the statute itself. There are very real challenges, Blaine, and I'll say this, I am asserting defenses right now in litigated OSHA cases based upon Loper-Bright and based upon the breadth of authority granted in the statute. These are very real legal issues that are going to make their way through the courts. That could mean you could end up, and I don't think it's going to happen in the next 2 years. It may take even 4, 5, 6 years, but I do think at some point you're going to have the Supreme Court looking at whether or not the OSHA Act itself is unconstitutionally broad on its face, and if so, broad. And right, it is a delegation of too much power to an executive agency. And if Clarence Thomas is right, and he gets 6 justices, well, all he needs is 5. But right now, the count would either be 5 or 6 that might agree. And what you're going to do is you're going to send Congress back to the drawing board and say, and then that's when the debate will really matter. Because this isn't just some theoretical academic discussion. This is a very real thing that we litigators, we OSHA lawyers, folks like myself, my teams at Ogletree, and some of our friendly competitors at other firms, these are arguments we're looking at. These are arguments we're actually raising in our cases. It could be very real.
Yeah, and what's interesting is, when that decision came out, reversing Chevron deference, that it's like, no, you got to go through the legislative process. You can't, you cannot just shuffle this off to experts in these agencies that are policing themselves or basically interpreting their own standards. How do you see the use of administrative law judges? I mean, they're judges, but they're appointed for life, right?
Yeah, great question, Blaine, because I was about to go there too, because here's the other thing. The other thing is that, I've been saying this for years as an OSHA lawyer. I tell clients all the time, hey, listen, if you don't like what OSHA does here, the good news is OSHA doesn't decide if OSHA got it right. Congress back in 1970 said, hey, we don't want OSHA to be like the National Labor Relations Board, where they are the judge, jury, and executioner. They are the prosecutor, and they're the judge, and they're they carry out the sentence. And we don't want it that way. So in order for that law to get passed in 1970, the legislative compromise was the creation of the Occupational Safety and Health Review Commission. Unfortunately, they didn't give it a distinctive enough name, and a lot of people think they're part of OSHA. They're not, or they're part of the Department of Labor. It's not. It is an independent agency, not even part of the Department of Justice. It has 3 commissioners appointed by the president, confirmed by the Senate. And then they have a group of around 25 administrative law judges, which, as you said, have these appointments. They're not lifetime appointments; they're terms.
Okay.
But the challenge is very similar to the challenge going on right now with the National Labor Relations Board, Federal Trade Commission, Federal Election Commission. It is that the argument is this: we should not, under our Constitution, we should not be setting up judicial tribunals in the executive branch.
Yeah.
That goes to Article 3. Judges reside in Article 3, not in the executive branch. And so,
yeah, you have a group of judges deciding whether or not an employer is guilty or not of violating some federal regulations or statutes. And these are special, I would say special judges. They're judges, or they act as judges. I don't know what background they have to meet, or if they go through an appointment process. But it is, again, another version of what we started with is, whether we like it or not, a political appointee. So if there are term limits, I can be the president of the United States, vote for me. And I can appoint the heads of that commission, and then they would select the administrative law judges. Is that correct?
Yeah, something like that, generally speaking. But here's the thing. Okay. Here's the thing. I actually like the fact that we have judges that are specialized, and that's one of the pluses of having a review commission the way we have it now constituted. Although, trust me, I understand the argument. And maybe they're right about that. We'll see. Again, full disclosure, I'm raising this defense in cases that the review commission doesn't have constitutional authority, and the OSHA Act on this approach. This is wrong, because I'm going to raise all the legal arguments I can. If I've contested a citation in front of the review commission on behalf of a client, I'm raising all the arguments, and these are new arguments that we're raising. They've been around forever. Just we didn't think they'd get anywhere. Now they might. But when I make the point of, I actually like the fact that our ALJs, I really like them. I mean, there's a group of about 25, and just like any group, there's a third you really like, a third you don't, and third in the middle. But they are all they all are very knowledgeable and experienced. They don't handle Social Security cases or other kind. They only do contested OSHA citations, and so they really do know the law. They really are a pleasure to work with. Judge Covett Rooney was the longtime chief judge. She just retired and is a good friend. Appreciate everything that she did in her service, and I really like the setup functionally. But I also understand the argument that constitutionally that may not be the way to do it. Maybe we need to have a review commission type setup in the Article 3 court system. So maybe you have, instead of doing regular district courts the way we have right now in the U.S. federal court system, maybe there are specialized courts that could be set up within Article 3. I don't know the answer to that, Blaine, but I think those are conversations that we're going to be having more and more and more as this issue continues to be discussed. Getting back to around to the first question of what's the most effective way to help workers and employers have a safer place to work.
I do like that idea. I mean, we have federal judges, and then we have these federal agencies that are vertical, I guess if you would call it. They're vertically disciplined. OSHA, EPA, the Department of Labor in general, those types of things. Yeah, I mean, making sure that you have staff judges. Yeah, they're all in the executive branch,
right? And so, sorry to interrupt everybody. They're all in the executive branch. The argument goes is that, well, they shouldn't be, because by way of the constitutional structure, there should not be judges in the executive branch. Now the question is.
Oh, right, yeah, you're right. So, that makes sense.
There you go. So yeah, that's and again a little bit more nuanced than that, but making it as simple as possible. That's the argument. And so, is there a chance that the review commission is itself unconstitutional? It's part of the OSHA Act, so I think it'll all be argued all in one. It'll probably come up in one case. Is the OSHA Act too broad? Is the review commission unconstitutional?
Yeah. Wow.
At some point, the Supreme Court is going to address that issue, and I think that's got legs. That's got more of a chance of getting through. Unless you end up with 60 votes in the Senate, which I mean, and I don't even have to count Republicans and Democrats on that, because I think this is going to cross party lines to where it'll be blurred. And I wouldn't even start off by counting Republicans on that. You got to find 60, men and women in the Senate to vote to get rid of Fed OSHA. And unless you have another plan in place ready to go, don't see that happening.
No, I don't.
And maybe that's what Congressman Biggs has in mind. I haven't seen anything yet, but maybe, if he were to put up some, because his proposal, his act he introduced was 2 sentences, I think.
Yeah.
Get rid of, this is an act to get rid of OSHA. What are we going to do? Get rid of OSHA. I think there's your 2 sentences.
Yeah. So some people call this a protest bill, which I understand. It's to raise awareness around a particular issue. And more often than not, it does stir conversation, which might lead to meaningful reform, hopefully. I mean, we're talking about it. I mean, which is interesting. Yeah, I also remember I just saw a case about workplace violence. I was reading the administrative law judge's decision on that. Just very keen on the general duty clause and tossed the whole case, the whole OSHA citation. But what was written and why, I was just floored by how well it was written and the logic that he used. So I'll have to send you that link. You probably already know about it, but
yeah, it's a case we all studied that one because again, it's one of the criticisms of Fed OSHA is the abuse of the general duty clause, and that's that case proves that there are cases in which OSHA is going way beyond what the statute authorizes. That's not what the general duty clause is supposed to do. You need to have a rule. OSHA's response is, well, we can't pass a rule. Why not? Because it takes too much time. It's more difficult. I mean, okay. And you employers are going to object to the rule anyway. So may as well just try the general duty clause, right?
That brings me back to, all right, kick it down to the states. They'll get stuff done a lot quicker.
That may be the approach. I mean, look, I mean, at first my immediate response on this whole thing was, no, we don't need to get rid of Fed OSHA. Let's just fix it. But maybe the fix is some hybrid. Maybe remains some sort of federal oversight, but it's minimal, and the primary function is served at the state level. Maybe. I don't know, Blaine. I'm neither a bureaucrat running OSHA, nor am I elected representative. I'm just a guy in the field working hard to try and help people have a safer place to work.
You and me both, brother, and we'll keep doing it regardless of what happens, which is what I love. So awesome! All right, well, hey, where can people find you? Obviously, find Phillip Russell on LinkedIn, but where can they find a little bit more about maybe your podcast that you got going?
Yeah, not hard to find at all. I'm in the professional services business, so I don't hide. But if you were to type in Phillip Russell with 2 L's in both names into your favorite browser, you'll either find a high school basketball player that I am not, nor have I ever been, or if you add Ogletree, my firm, to it, or just type in OSHA lawyer, you'll find me. And you can find me at our firm's webpage. Follow me on LinkedIn. I do a podcast through the firm called Dirty Steel Toe Boots. I'm not quite as disciplined about getting out the episodes like you are, Blaine. I just wish I could be more like you. But I do try to put out some thoughts on there. And I'll tell you before I go, I will say one issue I want you to cover is what's going on with OSHA right now. And we can maybe even do another episode. But it has been interesting to me to see what's going on with the agency right now in the field. We are seeing more inspections. They are spiking. And I don't have any data on this. This is just anecdotal. But we're a big firm. We got a lot of lawyers doing this kind of work. And my own practice, very robust. But more inspections than ever, broader scope than ever, and issuing citations way beyond what I think the evidence supports in a reasonable way. But I think, Blaine, that's what happens when you get an email that says, what 5 things did you do last week? So, and I asked some of my friends that work at OSHA, no names here, but I asked people at high level, mid level, and low level, how did that impact you? And, the answer is what you would expect. They're like, well, I want to make sure that everybody sees what I'm doing. And so I think right now what we're seeing is a little bit of a pendulum swing way the other direction. And they're doing
you can go too far. Yeah.
And we're seeing some of this going a little bit too far. So, I just actually the other day contested a citation without doing an informal settlement conference. I haven't done that in years. But
really?
It's because I always have historically said you should always do the informal. But this citation was so beyond the pale, so way beyond the scope. I thought it was a complete waste of time for us to try and even get it resolved at the informal. I recommended the client we just immediately contest it and go in front of the review commission. They agreed. I think you're going to see a lot more of that until we get OSHA to calm down. I think right now
Wow.
they're in the middle of this, and I love, I love and respect the men and women that work at OSHA,
Yeah.
but right now there's some activity going on that needs to be dialed back. They're going. Remember, my
All
job,
right.
hold them accountable
Yeah.
to the law. So let's do
There
that.
you go. Sounds good. Hey, keep fighting a good fight. And I know you have a personal attachment to improving workplace safety, like a lot of us do. So yeah, I love that you're also making sure that we keep our employees safe. It's good business. It's the right thing to do. And we'll keep doing what we do, man. Thanks a lot. And we'll get together on the next topic, and we'll bring you back and talk about all kinds of OSHA law and see what we can uncover.
Sounds good, Blaine. Thanks for having me. Always enjoy it. What a great discussion today.
I loved
Enjoyed
it.
every bit
Thank
of
you.
it. Yeah.
Yep.